Give it a minute.
Yeah. Good morning, everybody. We're just going to give it a minute while everybody gets logged in. Okay, it looks like we have 32 on right now. Good morning, everybody. Welcome to our MEEB Practical Employment Law Topics for Boards and Property Managers talk today. I'm Dawn McDonald. A lot of you know me. I've been at MEEB for 4 years now in the litigation department and handling employment law matters. Seth Barnett joined us in August. And together we have over 40 years of litigation and employment law experience. So we get a lot of questions on a day-to-day basis about the topics that we're going to be talking about today. So we thought it would be a good idea to hold a webinar. And of course, if you have specific questions regarding specific circumstances where you work, you can reach us at our email address or at our telephone numbers, which will be on the last slide of our presentation. And we can speak to you directly about those problems. We would ask that once we get started, you can put your questions in the chat box and we will address questions at the end. But Seth is going to start off with discussing independent contractor rules and why associations need to understand them. Then he's going to transition to the best practices for managing problem employees. And then that will segue nicely into how to conduct an effective performance review, which I'll be speaking about. And then the last topic is microaggressions, what they are and how to avoid them. And I'll speak to you about that as well. So hopefully we won't take too much of your time this morning, but we will start off with Seth.
Sure. Good morning, everyone. Excited to have joined MEEB and excited to shift my focus from working in the municipal field for almost 2 decades to now the condo field. There's a lot of overlap there, and that's kind of why I've joined MEEB and working with Dawn here to discuss some of these employment issues that are somewhat of hot topics in the last couple of years, and things that kind of we want to flag for you just to think about and make sure you kind of are always paying attention to some of these things and how pertinent they are to associations, boards, and property managers. So the first thing I wanted to talk about briefly was the use of independent contractors and comparing it to the use of employees. In the news recently, back in October, and I'll talk about this in a minute, the Biden administration announced that it was going to update some rules and regulations through the Department of Labor that concerned the use of independent contractors. And the important thing here is why are we concerned with classifying people as independent contractors versus employees? So the first thing to ask yourself is, do I want to use independent contractors? Do I consider the people who work for me employees? And am I doing this correctly? And does it make sense for me? So an independent contractor, we come across them in all forms. There's someone who's usually self-employed. And one of the key factors is that a company or an association, which is a corporation, you have the right to control the result of the work, but you don't have a right to control necessarily how it's been done. So think about it in the simplest forms as if you're an association and you're hiring a painter to paint the exterior of the building. You're telling that painter, in the simplest terms, what color you want it painted, and your hope is to what areas you want painted. You don't necessarily have a right to tell them what brushes to use, how to go about the work with, what types of strokes to use, things of that nature. And so they're an independent contractor. Many of the services you use for project-based things are independent contractors, but they're also sometimes they're the employees or the people who work for us on a more routine basis we want to use as independent contractors. And there's reasons why people want to use them. It can be cost efficient for a couple of reasons. You don't have to pay unemployment compensation for an independent contractor. You're not concerned with workers' compensation for an independent contractor. You don't need to pay overtime to an independent contractor. You can have flexibility with how you use them. You can use them for short periods of time. You can schedule them for shorter days of the week, less hours during the week. It allows you to plan more flexible to use independent contractors because you may not need someone for 40 hours a week, and it may be difficult to find someone who's willing to just perform your work for short periods of time during a week. So it may be someone who performs the job across several different employers. But the important question to know is, am I using an independent contractor correctly, and am I classifying them correctly? Because misclassification is one of the largest growing areas of litigation that we're seeing in employment law. And that is because there are many lawyers and many employees out there who believe they're being misclassified as independent contractors. And because of this, they're claiming certain things like I just mentioned. We're not getting our proper overtime or our proper wages, or we're being excluded from unemployment compensation or workers' compensation. And there's allegations that employers are violating the wage laws. And with those violations often comes larger penalties in civil suits. And it brings scrutiny from the Attorney General's office, of course. So the first thing we look at is the independent contractor law in Massachusetts itself, and the test that every employer should be asking when they're looking at whether or not you want to classify someone as an independent contractor. And in Massachusetts, along with 10 other states, it's what's referred to as the ABC test. And it's a test that all people are presumed to be employees unless you as the employer can meet the burden of showing that that employee falls within this test and is therefore an independent contractor. And it's a burdensome test. And the courts in Massachusetts especially, they lean in favor of the employee to provide that employee with the protections under the law, unless we can show and meet that burden of proof all three of these parts of the test. Now, they're not impossible, and there's many industries where they are possible, but with the rise of what's called the gig economy in companies like Uber and DoorDash and Lyft, there's more and more scrutiny on independent contractor status, because though the status of those employees is at the forefront and is being challenged. So we have this ABC test that I mentioned, and it's a three-part test. And the first question that we ask is whether the employee is free from control and direction from the employer. And it's not an absolute test. There obviously needs to be some oversight, of course, when you're managing even an independent contractor. But the questions that you ask when you're looking at this and to decide whether or not, is this person really under my control or direction? You're asking yourself, are we allowing them to work at their own pace? Can they set their own hours? Can they refuse assignments or come in on certain days of the week? While they're performing the tasks that they've been assigned, are they subject to supervision or oversight? Do they have to check in, make daily reports? In certain instances, is that person using his or her own vehicle or equipment? Now, a lot of the people that the independent contractor statute does apply to are people in the trades, specialized trades, anything from plumbing to electrical work, even landscaping, of course, all of these areas that many of you work in or bring people in with. And those are likely independent contractors. They're using their own tools, they're using their own vehicles and equipment. They're often free to hire their own help when they need more staffing. So those are the first questions to look at, whether or not we're free from control. The next question is whether or not the work being performed is outside the usual course of business of your company or being performed away from the primary place of your company. For property management companies and associations, it is somewhat of a different test, the way I would look at it, but it can be incidental. Certain, obviously with an association in managing and owning a property, many of these things are incidental and needed to manage a property and make sure that the maintenance is taken care of. But that doesn't mean that just because landscaping is part of managing the property and keeping the maintenance up to date, that doesn't mean it's within the course of business of the association. This question B, is often the question that the courts focus on the most. So it's really important to conduct a full analysis of whether or not this is truly something that's outside the actual scope of your business. And when you look at it, one of the questions you can ask is, if we didn't provide this service or perform this service, would our business still exist? And that's often the question that can help us characterize someone as an independent contractor. The last part of the task is whether that worker could provide the skill or service that they're being asked to provide to anyone who wishes to utilize it. What that doesn't mean is that they have to be allowed to perform. If it's a painter, they have to be allowed to perform the job across multiple projects at the same time, but they have to have the ability to do it. They don't actually have to be working for multiple people or whatnot, but if it's a Uber delivery driver, one of the questions is always, can that person also work for Lyft delivery, or can that person deliver for Amazon? And oftentimes those companies are arguing, yes, they can provide their delivery skill or their driving skill to multiple businesses. And that's why they should be classified as an independent contractor. So the use of independent contractors is wide across both property management and the condominium industry. And it's important that we make sure, in light of the ever kind of changing and the scrutiny that it gets in Massachusetts, that we make sure your classifications are correct. And Don and I are always obviously here to talk to you about any specific instance that you have. As I mentioned a minute ago, the hyper focus in this area has kind of been brought upon by the ride sharing industry, and a series of class action suits challenging the pay structure in those industries. That's obviously somewhat different than where we're hiring, whether it's maintenance workers or even property managers or front desk workers. That's different than these people who are out there setting their own jobs and their own hours and their own delivery schedules. But it is bringing scrutiny to the entire use of independent contractor status. And that's how we got to the Department of Labor announcing in 2022 that it was looking at from a federal perspective what the test was, and working to propose regulations to provide more protections to these workers. I don't believe it will change much in Massachusetts at the moment, because Massachusetts wage and hour law provides greater protections than federal law. So where it's not inconsistent, state law would control here. Our minimum wage is higher than federal law. The entitlement to unemployment benefits and workers' compensation is much broader than it is under federal law. So I don't believe it will change much in terms of Massachusetts, but what it is going to try to bring is kind of a national standard here. And so what remains to be seen is if and when these regulations get adopted. As we know, Congress doesn't move at the fastest pace there is, much like our courts, but we will certainly keep you updated on that. I want to shift gears, and Don, for the rest of this presentation and kind of talk about managing employees and employee behavior. And the first thing I wanted to talk about before we shift over to Don picking up the rest of it is managing difficult employees and disruptive employees. You know, for the last 2.5 years, a lot of employees have been remote, but we've certainly started over the course of a 1.5 years to shifting back to the workplace. And with that shift back to the workplace, you've kind of seen a rise in the way people interact with people and a change in it. And it's noticed across the number of discrimination filings and the types of discrimination filings that we're seeing. And because of this, we wanted to kind of flag some of these issues for you. And really, the goal with this is to try to get out in front of any employee behaviors, to minimize any disruption in the workplace, and to really make sure that we're doing that so we can avoid liability. As much as both Don and I probably like trying employment law cases, the goal is obviously to help all of you and our clients avoid that. We'll find plenty of work in other places, but if we can help you avoid a suit at the outset, that's really better for everyone. So here I kind of just list a lot of the types of behaviors that are pretty obvious that cause disruption and problems within the workplace. And they're, you know, everything from the rude, condescending, demeaning statements that employees make to each other, and they also make to whether it's our customers or, in the case of an association, to residents. And it's the, you know, oftentimes we have concerns with the tone they're using, their reaction to things. We mentioned shouting, throwing things, slamming doors, becoming verbally and physically abusive to coworkers and to residents when they feel challenged. Likewise, criticizing and pushing back, kind of questioning authority, and just continuously causing these type of issues. And if you look at it, sometimes you look at and see, well, a one-time things, you know, you're hoping it doesn't help. You see it and it's not a great thing, but you think, oh, it just happened once, maybe it's, you know, not too big of a deal. But when you start to see a pattern over it, even little things, and I think Don will talk about this in, you know, the phenomenon of microaggressions, it really becomes a significant issue. And the issue that what arises is often you're getting complaints of a hostile work environment or some sort of complaint of discrimination from another employee based on the disruptive employee's behavior. And we've seen it enough to know that the problem of a disruptive employee or an employee engaging in conduct that's just not appropriate for the workplace, it doesn't go away on its own. With that being said, any of us who are managers, the last thing we want to do is have that difficult conversation or take action about that disruptive employee. We all want to do our jobs, and our hope is that our job doesn't involve having to, you know, whether it's babysit or intervene or investigate or discipline. But the fact of the matter is that as managers, we have this obligation, both ethically and legally, to address these behaviors, to investigate complaints from other employees, and to do everything we can to prevent the reoccurrence or prevent something further from happening. Now, the ability to prevent the reoccurrence, that's not an absolute thing. We obviously can't guarantee that, but what we can't do is just ignore the problem and say, oh, it's never going to get better, or, oh, we tried. That's not enough. That's not enough. We owe it more to our employees. We owe it more to our customers and the people who live in our associations, and we owe it more to ourselves from a legal perspective, because we also want to avoid legal liability. But we want to ensure that our workplace is somewhere where other people want to work. So it's really important that we address these things as early as we can. And so there's some strategies that I wanted to lay out for doing that. And the first strategy is kind of taking an approach that hopefully from the outset, if we can take a proper approach, we may avoid this altogether. And that's really making sure that you have good hiring practices in place and making sure that you use the ability to use references, to cross-check those references, to really dig in to employment applications and really have a strong hiring process with interviews and whatnot. Now, the labor market is the instability of the labor market over the last couple of years makes it difficult. There is a shortage of good workers across all these industries. And oftentimes we find ourselves saying, we just need a body or we need to hire someone. We need to get someone in here. The pool of candidates we're looking at, it's so much different than it was 5 years ago. We still need to be vigilant about it, because if we're just bringing in people to fill spaces, oftentimes we find ourselves with these problems pretty quickly down the road. So it's really important to have a good hiring process in place, a thorough application. The law is ever changing as to what you can and cannot ask on an application. We won't go into that in detail here, but always happy to discuss that with any of you as to what you can and cannot ask on an application and what you should be asking on an application. The next thing is having the correct policies in place and making sure that you clearly communicate those policies to your employees. Whether it's through a formal handbook as an employer, or it's ensuring that you have a clear set of policies, at the very least, your discrimination and your harassment policies. There's model policies that mirror state law, but to make sure that your employees know that your employment policies with regards to workplace harassment, they're taken serious and they can be grounds for immediate discipline up to and including discharge. And that you should have at the outset, your employees acknowledge that they are aware of your policy and they've received a copy of it and they understand it. I think that's really important. And the same goes for, again, a discipline policy. As employers, you can terminate someone who has an at-will employment status with you at any time for any reason, unless, of course, it's for discriminatory or retaliatory reasons. But you should still have a clear policy as to the conduct in your workplace that is prohibited and the fact that it may lead to discipline and discharge. And again, whether or not that's in a formal employment handbook or that you just have a disciplinary policy, it's important to communicate it to the employees. So you set this expectation with them that what you're expecting is a workplace free of discrimination and harassment. Oftentimes people think they mistake a collegial workplace for a workplace where they can, talk as freely as they want and use the certain types of jokes they want and whatnot. Today's workplace is a lot different than a workplace 5, even 10 years ago. And a lot of the things that people will often justify and say, well, that's just the way I've always talked in the workplace, or those are jokes I've been making for 20 or 30 years. That's all well and good. It doesn't work anymore. It's not a justification. It's not a justification under the law, and it's not a justification that we can give to our other employees. The culture of the workplace changes over time, and with that, employers need to adapt and be prepared. Now, the one point I'm going to get a little more substantive into is how to go about addressing some of these behaviors. It's often times if there's an employee who's being difficult and disruptive in the workplace, it's fair to say that you may encounter situations where you're getting pushback from them about addressing their behaviors. And the question often is, well, what do I do if they ignore it, or they say no, or they just don't want to cooperate? So I'm going to walk you through that. And then the last piece is obviously the importance of conducting performance evaluations. And Don's going to walk through that in much greater detail. So if you have a situation with an employee who's been making rude remarks or arguing with a coworker, let's say, and that coworker, whether it's you as a manager, or you as a coworker, or you as a resident of an association, you observe this and you bring it to someone's attention, and you as the person who's the manager, it comes to you and you say, okay, what should I do next? Now, the first thing you should do is, based on the information you have, you just should decide whether or not this is an instance, using your judgment, where you can have an informal conversation with that employee, or that based on the allegations that you have, it's something that you should conduct a more formal disciplinary investigation into. And if you're unsure, again, that's where Don and I come in. We always talk to people multiple times a week about these kind of instances, and we're happy to guide you there. So let's say you're in an instance where you've had an employee who's just been, seems like they're in a bad mood the last couple of weeks, and they've been rude to their coworkers. Nothing that triggers a belief that there's some sort of discriminatory motive there, but just behaviors that seem to be disruptive. And so first thing you do is, based on the information you have, you try to identify what the problem is, and you ask that employee to meet with you. And rather than tell them that you're there to discipline them, it's important to let them know that this is a meeting to understand what's going on, and see if we can find the root of the issue or come up with constructive ways to address the issue. That you're not there to place blame on anyone. You're not there to find someone guilty. You're not even there at the moment to discipline someone, but it's something that needs to be discussed. Now, when you do this, and you'll know better than any attorney, because you'll know that employee, you say to yourself, well, I know this person, they've been working with me for 5 years. I can anticipate what that response is going to be. And we'll go through some of those typical reactions, but you do need to be prepared for the type of response that you'll get in one of those meetings. And so that conversation takes place. You discuss with the employee what the complaints are, the importance that this is an informal conversation, that you'd like to address it. You want to know what you can do to help and support them, but we really need to change that behavior. You document that discussion. And one of the most important things is to follow up with the employee. Oftentimes we have these meetings and we say, okay, we've talked to this employee, and you're going to get good behavior, at least for the next week or two. They're going to be on their best behavior. But they'll think the issue's set and resolved, and if you don't speak to them and follow up with them to see how things are going, or to give some feedback, then they may very well go back down that path again. Now, in the course of one of these informal meetings, if you decide, well, the information I'm gathering, this discussion is not going to be enough to get corrective action, you can institute a corrective action plan, a performance plan, or give out discipline, which may need to be taken to address the behavior that happened, but also to prevent the behavior from happening in the future. And so when I mentioned the employee response, as a manager or anyone, you're going to know that when someone's being confronted about their behavior, they're going to oftentimes, I don't want to say all the time, become defensive. They may become angry. And in that case, what I recommend is, if they become angry and start venting, to let them vent in that meeting, to let them get it out. Don't get in an argument with them. Be prepared that they're going to do it. Now, if it gets to the point where it is overly hostile and becomes accusatory, that's a time to stop the meeting and say, okay, we need to take a break here. We'll come back in a couple of days or so, revisit this meeting, but you should go home for the day. This isn't productive. And then decide whether or not, based on all of that venting and what you heard, okay, this isn't going anywhere possibly. Or can I pick back up here? Or do I just need to start speaking to other people? And is this becoming a disciplinary process? Most people will vent to kind of share their side and justify their behavior, but I don't believe it will always reach the level of that you need to stop this meeting and take a different approach. You know, sometimes instead of the anger, it will become tears in the same instance. You know, try to provide some comfort that, you know, give them a chance to calm down, let them know if they want to come back to the meeting. These things happen. You feel like you're playing armchair psychologist for a period of time, but these are employees, again, whose behaviors are being questioned. Again, like the first one, there may be some complaining and blaming. There may be some people who just don't want to talk at all. You can try to invite them to talk. You can ask open-ended questions, see if they'll answer those questions. Sometimes they just want to listen and leave. Again, that's why it's important to document these things and follow up. And sometimes there's people who are just unwilling, deny their behavior, unwilling to resolve their behavior. And again, that's where we need to reiterate our expectations in writing and continue to follow up with the employee, because just because that meeting is ended, we shouldn't consider the matter to be closed. So a couple of things that I just wanted to lastly highlight was, oftentimes during these meetings, an employee may, for the first time or tell you that they apologize or they're having a problem, and that problem is the cause of their behavior. And oftentimes that problem may be something, whether it's alcohol related, drug or chemical related, family issue they're having. They may raise that, and they may raise that in confidence with you. In these situations, one of the first things you can do is to refer them to an employee assistance program. The other thing to do is to ask them if there's that, explain to them the importance that the behavior still cannot be tolerated just because they've raised this issue there, but is there anything that we can do to support them? And again, those are things like referrals for anger management, the employee assistance program, suggesting they go speak to their doctor. They may, of course, they may use this as an opportunity to say they're having stress at work and they need to go out on leave. These are why it's important to document these conversations, because oftentimes people will use these conversations kind of as a opening to try to take leave or get or avoid their behaviors. So like I said, regardless of the fact that there's an impairment or they may claim a disability at the time, it does not excuse behavior, and it does not prevent you from taking any corrective action or discipline. These situations are unique, they're rare, but they do happen. I would recommend that before taking corrective action or discipline in these situations, that you talk to an attorney about the specifics of the situation, so you can make sure you get it right, because what you want to avoid is a small incident of yelling and screaming or arguing at work turning into a full-blown federal lawsuit about someone's job performance or discrimination. And with that, I'm going to turn it over to Dawn to talk about performance reviews.
Okay, so thanks, Seth. Let me make sure I get the right screen share. Okay, so conducting an effective performance review. This seems like a pretty basic topic, but you would be surprised how many people get this wrong. A performance review is a very powerful tool that managers and supervisors have to both develop their employees into the superstar employees that you want them to be. But also if you can't develop them into superstars and you have to make decisions to terminate their employment, the performance review can help you with that too. So what the main purpose of a performance review is, however, is to evaluate, provide accurate and actionable evaluation of an employee's performance. And what I mean by that, by actionable, is you want to be setting benchmarks for your employees. You want to give them some guidance, and employees want guidance. They want to know that they're doing a good job, and if they're not doing the job that you expect of them, most employees want to know what they can do to better satisfy the expectations that you have of them. You want to develop their skills that are in line with their job tasks, and the performance evaluation is how you is one of the tools that you use to do that. The problems with not conducting a proper performance review are that cursory reviews become just compensation announcements. And this, I've seen this a lot with many of the condominiums and property management companies. They tie the review to compensation. Those are actually two different things. Now, you can, of course, give compensation at the time that you're giving an annual performance review, but you don't have to. The review stands on its own, and it should be conducted whether you're giving additional compensation or not. Another instance is when you don't give any feedback about actual job performance. You simply check boxes that say that the employee is good in every category without saying anything else about it. That doesn't really provide the employee with the feedback that they need, and it also doesn't accomplish what the employer needs from their employees. The idea is to be giving directions. Other problems are that managers don't do reviews at all. So the employees just continue on doing their jobs every day, perhaps unsatisfactorily, and nobody ever says anything to them about it. That's an issue. Then, if it goes on for a prolonged period of time, then you've got a supervisor says, you haven't been doing this right for 5 years. Now the employee may raise what Seth was talking about. They can say, well, I've had a good review for 5 years. No one's ever told me I'm doing this wrong, and you must be discriminating against me because you're raising it all of a sudden. So that's none of this is ideal. A properly written and presented performance review can improve an employee's performance. It can improve the morale at the workplace, and it can also improve your turnover. So there are things that should be done before the performance review. There should always be clear standards by which performance is judged. Employees need to know what their job duties are, and you have to make sure that you remind them of that if they fail in any of those duties. And you need to do that on a regular basis, a weekly basis if necessary. But the performance review should not be the first time that an employee is hearing that you have problems with their job performance. You should be doing it you should be counseling, we call it, all the time. Effective reviews require a judgment about the causes of a person's job performance. So this can be kind of a difficult area for managers to to understand, and it's uncomfortable to make judgments about your coworkers or the employees that work for you. But you have to determine, are the performance issues that an employee is having a result of poor ability, or is it a result that they don't have any motivation to do their job? You have to think about whether training might help the employee do a better job. Is there any way that you can incentivize the job or the processes that they have to go through to get them to do a better job? Is the person in the right job? Sometimes you might have a good employee, but they don't particularly care for their job, or they're not suited to the role. You know, something that comes to mind is perhaps a person who has a great personality, who is, maybe you've got them assigned in the maintenance department, cleaning up the buildings, when perhaps a better fit might be that they sit behind the concierge desk because they have a good personality. So you have to consider whether you've got people in the right jobs. Consider whether it's time to replace an employee. Have you counseled them multiple times and they're not improving, or they're resistant to improving? And then, you know, you have your superstar employees. What are you doing for them? What are you doing to reward your superstar employees? So these are all the things that you have to think about before you actually sit down to write a performance review. You always want to convey positive intent to your employees. A review is about conveying feedback in order to get them to do a better job. If they do a better job, your job becomes easier, the buildings function better, everybody's happy and everybody gets along. In order to convey your positive intent, though, you have to be specific. You can't beat around the bush. You can't just say, hey, you're doing a good job. You have to be specific and describe specific instances or events where a person has either done a good job or has perhaps is lacking in some way, and give them an example of how they could do the job better, or could have handled a certain circumstance better. This is supposed to be a conversation. It's not supposed to be an interrogation. It's not supposed to be the manager dictating to the employee how things are supposed to be. The idea is to have a conversation with the employee. You want them to also give you feedback about what they think about their job. You want to ask them questions. Is there anything that we can do to help you do a better job? Do you think that you need training? You want to also explain to them what the impact is of any poor performance that they might be having. You know, if you have an example might be if you have a rude concierge sitting behind the concierge desk, you're getting a lot of complaints from unit owners. You want to explain to the person that, you know, maybe you're having a bad day, but you have to be aware that you're sitting behind a desk where you have a lot of visibility, and the unit owners become uncomfortable if you don't present yourself in a friendly way. So that would be an example of explaining the impact to an employee of their actions. And then you want to always make sure that you listen to them. If they have problems or issues that they want to discuss with you during their performance review, you should listen to them. And you always want to be looking to the future. So while you want to bring up specific instances of perhaps poor job performance in the past, you don't want to dwell on them. You want to look to the future and discuss with them what you think both of you can do to improve the situation in the future. Now, it's of course always possible that you cannot convey positive intent because you've already been down this road with a bad employee. They haven't changed, they haven't engaged, Their job performance continues to suffer. And at this point, you certainly don't want to check boxes and say that they're good employees. You need to have an honest conversation with them, and you need to talk about transitioning them out of the job. Or let them know, you might give them a last chance agreement. You might put them on a performance plan, which is a set of benchmarks that if you do A, B, and C by such and such, we're going to have a meeting on such and such a date. And if you've accomplished these things, then we'll talk about the next set of goals. Otherwise, we might be talking about your termination. So you want to be clear with them. You don't want to beat around the bush. You want to make sure that they're aware. If they're a problem employee, you want to make sure that they're aware that their job is in jeopardy. And you want to work with them on that. So what you do after the review shouldn't be the end of it. You don't just have the meeting, give the person the review, and then never talk to them about the content of the review. You want to always follow up. You should always be setting goals. And then if you see that you've got an employee who's achieving the goals that you talked about, you want to give them positive encouragement and reinforce the items that you discussed to make sure that they know that you're paying attention. And if they're not achieving the goals, you want to let them know that too. You want to say, remember we talked about this during your review, this is an opportunity for you to correct this, whatever the behavior is. So that transitions into microaggressions, which if you take Seth's portion on handling problem employees, combine it with the handling of a performance review, and then microaggressions goes along with all of this. So I will confess to you that I have some difficulty with this particular topic, getting my head around it. So the definition of a microaggression is the everyday slights, indignities, put downs, and insults, whether intentional or unintentional, that communicate hostile, derogatory, or negative attitudes towards stigmatized or culturally marginalized groups. Types of workplace microaggressions. There are behavioral microaggressions. When you're communicating, when somebody communicates a message with actions or symbols that display an insensitivity to identity stereotypes. Environmental microaggressions, when a lack of representation and diversity, including gender, race, ethnicity, and sexual orientation. Verbal is saying something that may not outright appear to be, but is disrespectful or offensive to a marginalized group. So one thing I can tell you is I would be willing to bet that every single person who's listening to this webinar has committed a microaggression, including myself. And I would also be willing to bet that you have suffered from a microaggression, whether you know it or not. I mean, this is really everyday comments that you may have no idea are offensive to individuals that you work with. So you have the overt microaggression. It comes across as discriminatory or prejudicial behavior, abuse, or harassment. It's often hard to pinpoint because it's not obvious, it's not malicious, and it can be unintentional. I can give you an example of this, something that I did. I had an assistant who was fantastic. She was a great assistant. I got along very well with her, loved her. She was a US citizen, but she was born in another country. And I asked her where she was from. I was genuinely interested. I had no negative intent towards this. When I heard for the first time about microaggressions, I asked her if she had been bothered by my asking her where she was from, and she was not bothered. She didn't know what I was talking about and why I was asking her the question. But this is an example of a microaggression. If you ask somebody of, I would say somebody with an accent, or somebody, you know, somebody, a person of color, where they're from, you're assuming, or so they say, you're assuming that this person is from someplace other than the US, and it implies that wherever they're from is not as good as the place that you're from. So that is a microaggression. There are categories of microaggressions: micro assaults, micro insults, and micro invalidations. Each type can have a lasting effect on the target's ability to experience belonging or social acceptance at work. Because the subject is not often discussed, some aggressors may not realize that they've crossed a line by showing bias to someone's class, race, nationality, religion, age, sexual orientation, gender, or disability. So this is part of the reason I wanted to discuss this today, is just to raise your awareness that this is out there. At the moment, there's no actionable litigation suing somebody because of microaggressions that I'm aware of. It goes hand in hand with the discrimination cases. There may be some facts in a discrimination case, talking about, you know, various comments that were made to a person, but microaggressions on their own, at least at this point in time, are not actionable. So raising awareness and just letting you know that this is out there, letting you know the types of comments that are problematic, will hopefully be helpful to you in handling issues in your workplace. So here are some examples. Telling a woman she's bossy. This demeans a woman's leadership and management skills. If I had a nickel for every time somebody told me that I was bossy, I probably wouldn't be presenting this seminar to you today. But it's a real issue. It's out there. And you shouldn't tell any women that they're bossy. Saying you're so articulate to a person of color. The person saying this is making an assumption that since the person is of color, the person speaking to them did not expect them to be well-spoken. Scheduling important deadlines on a religious or a cultural holiday. This communicates the prioritization of American dominant holidays, such as 4th of July or Christmas. Claiming that you have OCD because you're organized minimizes the experience of people who actually have OCD. Asking questions such as where you're from, know where are you really from, assumes someone was not born in the US and makes them feel like an outsider. So these are some of the examples of microaggressions. I'm sure you can appreciate that a lot of these statements, I would, you know, dare say that the person expressing them is not being intentional and not trying to intentionally make one of their coworkers feel badly. But intention is not part of the equation. You can commit microaggressions without intent. So this is out there. This is going to become a bigger issue as we move forward. More and more law offices and lawyers are getting up to speed and writing policies to deal with these kinds of issues and statements. So it's something that you should be aware of, and you should think about in your dealings with your employees. So this is just what I was just saying. The businesses must acknowledge and focus on addressing microaggressions in the workplace to show that such actions won't be tolerated. You should have zero tolerance policies for discrimination of any kind. And employers have to clearly communicate their policies. And this just is reinforcing what Seth said earlier when he was talking about dealing with problem employees. Supervisors should offer workplace microaggression training to help their workers become more aware of the incidents and how to avoid them. And if one of your employees complains to you that somebody's committed a microaggression against them, you have to take action. Even if it's just having a conversation with the two employees to prevent the situation from escalating. At the end of the day, employers are responsible for creating a safe and inclusive environment for all employees. Not all workplaces do this, but creating a pleasant work environment by handling problem employees, by giving proper performance reviews, by addressing microaggressions, by properly classifying your workers. All these good employment law practices that we encourage you to adopt will make your workplace more productive, more profitable. It keeps turnover low, keeps happy employees, and it makes your jobs easier. Acknowledging the examples of microaggressions in the workplace and addressing them is the first step toward creating a work environment where all employees feel appreciated and welcome. So we're going to open it up for questions if you have any, but if you need any help in the future, feel free to give us a call or shoot us an email and we can help you with any of these issues. Certainly the microaggression issues are murky, relatively new, and we can work through those together moving forward. So it looks like we have a couple of questions. They are both for Seth.
Oh, we could share. I don't know if everyone can see them or not, but David Abel had a question about requiring small contractors, and I think a lot of people see this. There's oftentimes small contractors, unit owners want to hire, but the association requires workers' compensation insurance, and oftentimes these small contractors are one-man shops that do not have this type of insurance. And so how do we deal with it? And it sounds like what you've been doing is there's an indemnification and waiver requirement with the trust. I always look at workers' comp insurance or hiring someone without it as it's essentially a form of gambling. It's gambling that you shouldn't get involved in for many reasons. The first is in Massachusetts, failure to have workers' comp insurance can result in fines and penalties. It can shut down the work. The more significant thing is it can leave you as the property owner or unit owner paying that injured person who might have come in just to fix, patch up some drywall or paint a wall. And if there's no workers' compensation insurance, it goes to the project owner. Now, I think the best thing that you're doing is an indemnification agreement, because if that person is injured while walking in the common area, they may come after the association. So I think that the policy in place should certainly be that you need to have workers' comp. If you're not getting it, the indemnification and waiver is the next best thing, but I still don't think that's the best thing you can do, having that workers' compensation insurance, because what we want to do is avoid the uninsured, you stepping in essentially as the contractor of that project with your own insurance. And if your own insurance doesn't cover that, and it may well not, because oftentimes a general liability policy may exclude or disclaim claims brought by people who are uninsured working there without proper permitting or insurance or licensure. So it's really a slippery slope to do that. And so I think you asked, can a sole proprietor, somebody else just asked, can a sole proprietor file a claim against the workers' compensation policy? They may try. I don't necessarily think it would be successful because they should be maintaining it themselves. And I think that's another reason why in any of these instances, you need to make it clear that they're requiring their own workers' compensation. And at the very least, have that indemnification and waiver requirement. And part of that waiver is that they are not making a claim against your workers' compensation policy, and they're indemnifying themselves against any injury. Again, there's always an attorney on the other side who's going to try to find a way around that. They're going to try to argue against it. And that's why really it's important. David asked if this is just for unit work. So if it's just for unit work, the concern I would still have, as you know, for any association, is if that person's injured coming to and from the property, if they're physically injured somewhere else on the property, whether they're walking from their car across the parking lot to the site, that still may trigger unemployment insurance, because workers' compensation policy, because they're at work. They're going to argue that they were injured at performing their work when they went to their truck to carry their tools or whatnot. So, you know, that's why it's best to have the policy, even though it would be at the unit. Again, the other piece is you can't control what that contractor is, who they're going to file a claim against necessarily. They may not be sophisticated enough to understand the distinction between common elements in a unit. So depending on where they're injured, they may make a claim that it's against the association. So I think that it's important for the trusts to have a policy that workers' compensation is required in these instances. And if it's not required, I think that the indemnification and the waiver requirement is necessary. That you need the unit owners indemnifying the association, but it's important that the unit owners themselves have adequate insurance in this scenario. Because if nobody has adequate insurance in the scenario, any attorney on behalf of an injured party is just going to be chasing the deepest pockets available, and that very may well be an association. So there's no right answer, because every scenario is different and every injury might be different. But I think that the important thing is really hammering home the need for workers' comp and why it's important, even when it's for a unit owner.
I'll answer Bill's question just very briefly, which is, how does a condo prevent someone who is the management company employee not to be considered an employee of the condo? That is the topic of an entire separate seminar or webinar. That is a question regarding the joint employer relationship. But the short answer is, management companies, if the employees are your employees and they work at a condominium, you are responsible for managing your employees. Similar to an independent contractor situation, the board should not be managing the employees. The board should not be directing what they should be, you know, can you go clean clean the common area bathroom right now because it's dirty? Can you, go over and see unit owner in 405 because they have a maintenance issue? The property manager should be doing that. The board members should not be getting involved in day-to-day operational issues. They should not be giving performance reviews. They should not be giving raises directly. The employer gives the raises, so we all know how it works in the condo world. So the board members, the proper way to address it is the board members say, here's a list of our expectations and what we expect from our employees, from your employees, property manager. And then the property manager assigns the people. If the board's unhappy, as they would be with any vendor, you speak to the property manager. They manage their employees. They give performance reviews. They give discipline. The board members shouldn't be doing it. So that's the short answer, but that is an entire separate seminar, as I'm sure you can imagine. So we are past time now. Thank you everybody for attending. The materials will be available after the seminar, the recording and the PowerPoint,
Yeah.
If you would like it.
I believe the recording will be on our new YouTube page as well.
Oh.
If you search Marcus Arico, either on YouTube with some of our other past webinars. So.
Okay. Thank you everybody for attending.
Thank you, everyone.